I thank you for logging on to our website and your interest in planning with purpose. My name is Paul Grant. I'm the founder of the firm and wanted to take you through just a brief discussion of some estate planning issues. What does a will do? What does a trust do? Those are the two major instruments that an attorney can use in estate planning. And then also wanted to introduce our unique process. We have a relationship process that, like I said, is really unique in the industry. And then I'll even give you some pricing ranges that we use, so be sure to watch it all the way through to the end. When you finish this, then we'll be able to get you on the calendar for an opportunity to sit down and we'll discuss you personally. Well, let's get going here. Wills and trusts, like I said, the only two instruments an attorney can use when doing estate planning. What's the difference and why would one instrument fit you better than another instrument? Well, let's talk about the basics. First of all, a will. A will is a more rudimentary document, and it has four major purposes. First of all, it tells us who, should you die, is going to close your estate. That is known as a personal representative in Washington, or some people call them an executor. So it names the individual that would have the legal authority to sign on your behalf, move property, collect assets, and then is responsible for paying debts and also making distributions to the beneficiaries. Well, that's the second thing that a will does. It names the beneficiaries. It tells us who receives whatever is coming to the will. The third thing it does is it gives court instruction. So there has to be legal sufficiency around a will. And in essence, in Washington, it's called a non-intervention probate. We want to have legal authority to come to the court, but we also want to say, hey, court, unless we come to you, we really don't want you poking around in the probate process. So it gives legal sufficiency as number three. And then number four, if you have minor children, it would name guardians. That must happen in a court structure because we're transferring permanent guardianship to someone else. It takes a judge's order, must go through the probate process. So a will does those four major things. Now, there's ways that you can avoid probate even when using a will. So for example, if you own a bank account with a spouse or with someone else, then that individual would actually receive legally the entire bank account should you die. Why? Because it's joint. It means that there's two people on it, so one person passes away. The next person who is jointly on the account, they win. They get the asset. Another way you can do a probate runaround is by making sure you have beneficiary designations on everything. A beneficiary designation for your investment accounts, maybe your 401k or IRA accounts, your bank accounts, and those types of assets. What is happening is you're actually signing a contract with the financial institution, and even though none of us actually read it, there's a section in there that says if you die and you've named a beneficiary, we will make sure that the account gets to that individual or to those individuals if you name multiple. So those are a couple ways to use a will but yet not end up in probate. However, we have a couple assets that we typically own, businesses, houses, property. Those don't have beneficiary designations, and ultimately those may end up heading towards the probate process. The other thing about using a will is that it's really just a check writing instrument. It really cannot resolve any tax issues. It really cannot resolve any protection issues for the next generation. It gets really sticky if you have money going to a minor child through a will, because the court's going to want to make sure that they capture those assets and watch over them. So when you use a beneficiary designation or a joint account, everything just simply gets into the hands of the people that you want. I've seen many plans where there's a beneficiary designation and it doesn't match the beneficiaries on the will. So there's oftentimes a disconnect when using a more simplistic or rudimentary plan. But a will does give you your voice. It does these four things very well. It tells you who's going to close your estate, who gets your estate, court instructions, and guardianships. So it does give some positives to make sure that you've used your voice of who is going to close your estate and who gets it. But again, it is a more rudimentary, more simplistic document in most times. So let's talk about a trust briefly. So a trust is a very different instrument. And I have a little bit of a prop because, well, if you come to the office, I'll even share my trust with you. But this represents a trust. So a trust is an instrument that, like the candy bowl, I would ask you a bunch of different questions and I would create the trust itself. Now, I put the trust maker, those who create the trust, their hands are underneath the bowl. Whoever holds the bowl is called a trustee. They have the power then to reach in, grab the assets. You can buy, sell, trade, give them away, consume them for yourself. And so when you have a trust, you are in full, absolute, complete power and control. It's your trust, your assets, and so therefore you can make adjustments to this and you have full control over everything. The reason we want to get all the assets into the trust, so the candy of your life, we want to make sure that it gets into the trust itself, because when it is retitled to the name of the trust, that means these instructions that we've created attach to the asset. That's what we want. Now there's a couple assets we can't put in trust. Number one is an IRA, 401k, 453b, any type of retirement account, including a Roth IRA. Anything that has a tax-deferred status to it, by IRS law, it must stay in your name. But that's okay. If you pass away, we're going to redirect it to the trust, because this is where all the instructions and all the hard work went during the estate planning process. And then it would end up being safely placed into the trust at your passing. Another asset that we don't put vehicles in, and that's just because Washington has a non-probate way to move in a vehicle. So retirement accounts, they don't go into the trust itself. But when you create a revocable living trust, the revocable aspect part of it is that you're in full control. It's your assets. The living component is that we will take and spend quite a bit of time in making sure that the instructions you leave in the instrument are sufficient so that if you ever experience a disability, meaning you need help and assistance at some point in time. As a matter of fact, if you're 65 or older, there is a 75% chance that you will need assistance for a period of time during your life. So therefore, we need to make sure that we have strong instructions instead of just general statements. So when you use a will, you have a financial power of attorney. Financial power of attorney, necessary document even with a trust, but what it's doing is it's giving access to an asset. It doesn't give instructions on how to use the asset for your best interest. That's really where a trust in that revocable living component comes alive and is much more in depth than utilizing a will, financial power of attorney, healthcare power of attorney method. Again, those documents are still in a trust design, but now the trust is the workhorse instead of the financial power of attorney. Because a will, that only comes alive should you die. So you pass away, the will turns on. The revocable living trust is a living document that you use during your lifetime. We want to make sure that we spend really good time giving solid instructions on how to utilize your assets during your lifetime for your benefit in a way that you would like your assets to be used. So we spend quite a bit of time in the counseling session going through that. Now also, what happens then should you pass away? If you're married, then we make sure that your spouse is well taken care of in the way that you envision. Most of the time that's very liberal, and that we want to make sure the surviving spouse has full, absolute, complete access to things. There are different ways to help close this down for Medicaid purposes and other things, but the general rule of thumb is that the spouse is going to have full absolute access to everything in the estate. Then when both spouses die, or if you're single when you pass away, things then move to your beneficiaries, whether it's children, whether it's nieces and nephews, brothers and sisters, charities, doesn't matter who it is. But now a trust actually is a very strong benefit to those that we leave behind. How is that? So during your lifetime, if something happens, you hit somebody in your car and it's your fault, someone can come and take your assets. This is not an asset protection trust to you. However, when you pass away, there is a lid that goes down on the trust assets. And now this becomes one of the, if not the strongest shield known in law for your beneficiaries. So, I have 2 daughters. For me, if one of my daughters, after I passed away, ended up going through a divorce, how much money would I want my son-in-law to walk away with? Yeah, you know the answer already. It's 0. What if my daughter made a driving error, made a driving mistake, and boom, hit somebody? Would I want the creditor just to simply come and be able to take everything from her? And those answers for me personally are no. I would rather set up a way to protect my girls if it's possible. And that's what a trust does. That shield goes up and over, and now very much like the iPhones of old, which I loved, because now they use your face. Those are ridiculous. But the iPhone that used your fingerprint, then it opened up. That's what a trust does. The beneficiary can go and use their fingerprint. They're the only fingerprint that can open up the trust and have access to what is there. A walking away spouse, a creditor, health issues. The trust becomes very protected when we leave it properly and when it's administered properly to the next generation. In addition, there's great tax advantages when we utilize a trust. So if you're exposed to an estate tax in Washington, if you have more than $2.2 million as an individual, or if you're married, 4.4, then using a trust is going to be a benefit, because as we leave money to the next generation, there are estate tax benefits to that generation when they utilize that trust properly. So also, contrary to common belief or what you might find on Google, there's actually taxing benefits as far as income tax when the trust is properly set up. Now, not all trusts are created equal, is the unfortunate part, is that most trusts I review don't have those protections, don't do the estate tax generational passing properly. So therefore, most trusts I've seen are not sufficient. So even if you have already done your estate planning, it's great to come in and get it reviewed to make sure that what you value for your family is put into the document accurately, and that you will have the confidence that it's actually going to protect and move your assets and your wealth to the next generation. Whether you have a lot or whether you have modest means, it doesn't matter. We can set up a family plan that'll ensure generational protection if that is your passion. Now, so there's kind of the difference between a will-based system and a trust-based system, which is a will-based system. It sends money to the right people. That's a good thing. A trust system sends it to the right people, but it can also accomplish tax objectives, protection objectives, and generational objectives if indeed that's what you desire. So different instruments, different purposes. Most of what we do here is trust design. We utilize trust for long-term protection. And also what is very unique in our firm is that we're not a one and done firm. So we actually have a relationship program that when we use a revocable living trust, we invite you to stay a part of the firm. What does that look like? Well, on an annual basis, we will send you a review of your trust decisions. It's a document that says, here are all the major things that you decided in your trust. Has anything changed from your perspective? We'll also send you an asset list and make sure that all of your assets are in the trust. If we have an asset that is outside the trust, there is a risk of probate. Now, we take care of your IRAs and stuff because, like I said, those are supposed to be out. But there's a risk of probate. So we actually want all of your assets into the trust, instructions attached. So we send you a review every year of your assets to ensure indeed they are in your trust properly. And in the relationship program, then you can send it back to us and you can make fine-tune adjustments. Now, the average fee is around $1,000 a year for that program. So it can go up to about $1,500 for some, depending on the complexity of what we had to put together and what is going to be maintained over the years. But if you're already paying an annual fee, how much more do you want to pay if you have a fine-tune adjustment? It's okay, I already know the answer. It's nothing, of course. And so that is the program. If you need to make a fine-tune adjustment, you tell us on that form that we send you. You tell us you update your assets. If you have a new asset and you need help getting it into the trust, we're here for you and we want to help you during the relationship process. So that's why we have a relationship that is ongoing. In addition, I don't charge clients for emails or phone calls, so there's no clock that goes on for me. And so we want to have clear communication. And also, the other benefit is that the law keeps changing. Tax law keeps changing. So how about my perspective as the attorney? Well, as the attorney, things always are adjusting. I make fine-tune adjustments in my documents all the time. So how do those get to you? So talked about you having the ability to communicate to us. Well, every 3 years, we're going to invite you back into the office and we're going to reprint your trust and all your power of attorneys. And that way, any of the legal work that I've been doing can be recaptured. Any amendments that we've made with your desires, that's recaptured. And we print one clean new document and it's updated and it is now ready to meet the challenge should you ever have a disability, in other words, need assistance, incapacitation, or if you pass away. What I find when people from the public call and they say someone just passed away and they bring in a document, that document tends to be well over 10 years old. And then I, as the attorney, am trying to make that document work to fit the circumstance. You know, if I have to work really hard to make the document fit the circumstances, that's not a good document. So our philosophy is, how do we utilize the initial process to build a really strong document for you, your vision on how you want to help your family. That's what our goal is. But it's more than that, because the law will change, family will change, your finances will change. Through relationship, we won't have that continue drop off in the legal, tax, or personal structure. Rather, at most, we are 3 years out in almost any type of client of making sure that everything is at its highest, best use to meet whatever may come our way. So that's our relationship program. In addition, we have annual training sessions for successor trustees. Maybe that's a child, maybe that's a sibling, maybe that's a best friend, who you would trust that if you needed assistance, they would manage your trust assets, they would close your estate. So we want to train them. It's one of the worst experiences to lose someone that you love and then find a document with an attorney's name. And if they're still in business, if they haven't retired on you yet, then to walk in blindly to that law office. That's a bad system. But that's how most of the law offices work in the public. So wouldn't it be far better if there was an opportunity for your successor trustees to actually be trained in what it would mean if you passed away and what their responsibilities were? What would it mean if you had a disability and needed assistance in your lifetime? That's a very different role. It's deemed the same thing as successor trustee, but boy, that's completely different. And how about the next generation? What if we educated them on here's what a trust can do? This is the power of a trust. It will protect you both with taxes, against divorces and relationships, and long-term generationally. Wouldn't it be great if there was someone who would actually train the next generation? Well, that is a part of our relationship program as well. So there is some quick hits. Thank you so much for taking a moment to watch. We've covered kind of what a will can do, what a trust can do, the relationship program, which is unique in the industry, and I promised you some pricing general guidelines. So my minimum to do a revocable living trust is $7,500, and it goes up to $15,000. So someplace in the middle is where most clients will land in order to move forward and get the assistance that they need. Our system is very different. We're very detailed. These are strategic and personalized plans that are not just your average run-of-the-mill change the name of the trust and change the signature page. It is not templated. It is specifically for you, specifically to meet your challenges, specifically to meet your tax needs, your family needs, if you have special needs children, if you have whatever dynamics in our families, because we're all different. Every plan has to be different. Your neighbor's plan can't work for your family, nor can yours work for your next door neighbors. So that is the pricing range. I hope this information was useful. It gives you an introduction to me, an introduction to our firm. And again, thank you so much for watching. We hope to get you back in here now and have an opportunity to meet you personally, go through your assets, and actually talk about what your passions are, what your specific needs are. And I look forward to meeting you. Thank you so much for watching.